Is your company involved in a legal dispute in Denmark? Then this is for you. I am Nicholas Keller. I'm a lawyer and a partner at a large law firm, and I assist our international clients with their activities in Denmark. Whenever our clients get involved in a dispute in Denmark, be it court case, litigation, arbitration, then they tend to have the same questions. So I'm making this video now to answer most of those questions. So I'll take you through what you need to know about litigation and disputes in Denmark, and I'll add our own tips and tricks and best practices along the way. So basically, we're gonna look at the questions of how long time does it take, how much does it cost, how does the court system work in Denmark, and also differentiate it between ordinary courts and arbitration, and just make you ready for whichever dispute you are facing currently. But let's dive in. To answer the first question we always get is, how long time will this take? If you have a court case in the ordinary court system, then we do have a 2-instance principles. You can always appeal the case. So that means that you should be prepared for fighting basically in 2 instances. Each instance, I would say, you should expect would take 1 year to 1.5 years for the district court, the first instance, and then 1 year, 1.5 years for the appeal instance, typically the so-called high court in Denmark. If we are looking at arbitration, it differs a bit because arbitration is a one-shot court. So you would only have one instance to make your case, and they will make a decision, and both parties will need to abide by that. So it would only be typically 1 year. So arbitration is faster than court cases, but there are pros and cons to both of them. So that's basically how long time it takes. So 1 year to 1.5 years for each instance as a main rule. So how much does it cost? And here we need to break it down into 3 different items. If we start with the court fees, the fees you need to pay in order to file the case and also to go to trial in the actual case, I have included 2 examples. If we have a claim of 1 million euro and 50 million euro, just to take cases in both ends of the spectrum. In the ordinary courts, we'll do arbitration afterwards. In the ordinary courts, you will have to pay a small fee, very small fee, when you file the case with the courts. Sometimes you would have to make a deposit to cover any legal costs which will be awarded afterwards. But that only applies if you're a non-Danish entity, so a non-Danish company who is involved in a dispute in Denmark. Once the date for the actual trial, the actual court hearing has been decided, then a substantially larger court fee must be paid. If we do look at the examples, if we have example 1, which was you had claimed for 1 million euro, then you would have to pay in total to the court, you would have to pay 22,000 euro. And if we take example 2, and this is where it becomes interesting and really shows the difference between the ordinary courts and arbitration. So remember, the small claim was 22,000 you would have to pay during the 1 instance court case. If we do take the other example, example 2, a larger case, 50 million euro, then what you have to pay is 22,000 euro. So exactly the same number, because there's a cap on the maximum amount of court fees that you will have to pay. So it tends to be cheaper in the ordinary courts because there's a cap on the maximum court fees. If we do look at arbitration, then it kind of goes along the same lines. You will have to pay a smaller fee when you initiate the case, when you file the claim. And then you will always have to pay a deposit for the subsequent court fee or court expenditures for the arbitration tribunal. And that deposit will have to be increased as the case progresses. The court fees themselves depend slightly on the arbitration forum in Denmark, which forum it is, and also whether it's 1 or 3 judges. So I will provide some intervals here. So we remember that from court cases it was 22,000 euros for both the smaller and the large claim. And here, if we do take the examples in comparison in arbitration, if we have example number 1, the smaller claim, 1 million euro, then you can expect to pay court fees in the interval of 47,000 to 125,000 euros. So somewhere in that interval, you could just average it at maybe 90,000 euros. So substantially more than the same smaller claim in the ordinary courts. If we take example number 2, the claim of 50 million euros, then the interval would be higher. So it would be between 118,000 all the way up to 534,000 euros. So that is a substantially larger court fee or arbitration tribunal fee than in the ordinary courts. And in addition to this, sometimes there may be fees for renting rooms, transportation for the arbitral judges, the arbitrators, and sometimes also food expenditures, depending on how long time the actual trial lasts. But bear in mind, even though the arbitration costs are higher in terms of the cost you pay to the court or to the arbitration tribunal, then bear in mind that it's a one-shot incident, so you only have to pay it once, and there's no possibility of appealing. So that's a bit on the court costs, but we do have other costs as well. Obviously, if the party that loses the case will have to pay certain legal fees to the winner of the case. And in theory, if we look at the Administration of Justice Act in the court system, in the ordinary courts, then it says that the losing party must cover reasonable legal fees to the winning party. So in theory, you should get your expenditures covered, but in practice, it doesn't work like that. In practice, you will only receive a fraction of the total cost that you've actually incurred to your lawyers, etc. As an example, if you have because it's based on a certain stair tariff, so example for a court case of 100,000 euro, just to take a smaller, easy example. So for a 100,000 euro case in the ordinary courts, you will be awarded legal fees of probably less than 10,000 euros. And you can't really go to court paying your lawyer less than 10,000 euros. So see it more as a small band-aid or a small compensation, but don't count on the losing parties' legal fees to actually cover your actual legal costs. An exception to the rule will be in IPR cases, so basically intellectual property. Due to an EU directive, we do see higher legal fees being presented and ruled over in IPR cases. So if it's an IPR case, expect that you will receive, or if you lose, have to pay more. So it would be closer to the actual legal costs that the parties have had during the court case. And a side note here, which is quite important, is how do you know who won? Obviously, it's quite simple if you win the full amount, the full claim that you have made, but quite often that's not the case. So let's take an example. If we have a court case and we have claimed for 10 million euro, and then you only get 5 million awarded, then who have won? In Denmark, we have an unofficial rule of thumb that the courts actually tend to abide by, which is the 10% rule. So basically, if you get awarded more than 10% of what you initially claimed for, then you will be considered the winner and you will be awarded full legal costs. And when I say full, I mean under the tariffs we just discussed, so it's not full that it covers everything, but you would at least be considered the full winner of the case. If you win around 10% of the case, so in this example where we claimed for 10 million and you only win 1 million, then it will be considered more of a tie, and sometimes no legal fees will be, or legal costs will be decided on. So each party will bear their own costs. If you win less than 10%, even though you have won, you will be considered the losing party and you will have to pay to the opposing party, the defendant in the case. So there is a tip here, and it might seem counterintuitive, but the tip here is that if you have made a settlement offer previously, then consider disclosing it to the court. And this is why. If we take the example of the 10 million euro claim, then maybe you knew that, okay, this claim consists of 3 different items. Let's say it's 3 different construction projects you've had in Denmark, and you know, okay, if we're really lucky, we're going to get 10 million. We would probably be happy to only win 2 of the 3 projects that are disputed. Okay, that would be, let's say, 2 million. And worst case, we're only going to win 1 of them, and let's say that's 500,000, just for sake of the example. So if you only win 1 of them, and it's the 500,000 out of a 10 million euro claim, then you will be considered the losing party, as we just discussed, and then you have to pay legal costs to the opposing party, even though you won 500,000 euros. But what you can do, if you have made a settlement offer previously of, say, 2 million euro, because that's 2 of the 3 projects and you were kind of happy about that, okay, if you present that settlement offer to the court, then that will become the new 100%. So basically, it's no longer the 10 million claim that the legal costs are measured based on. It's now the 2 million settlement offer. And what is 10% of 2 million? That's 200,000. So in this case, if you do only win if you're only awarded prevail over 500,000 euros, and you have presented your settlement offer, disclosed it to the court, then you would still be considered the winner, because 500,000 obviously is more than 200,000. So it's kind of a trigger the trade, if you will, especially beneficial if there are certain parts of your claim that are not very strong, or if you just want to kind of hedge against the risk of paying high legal costs to the opposing party. And we do this a lot. It's on a case-by-case basis. The risk of disclosing your settlement offer is that you kind of you can appear weak, that you don't really believe in your case. But as a main rule, I think you should always consider it. So that's the legal costs awarded to the winning, or the legal fees awarded to the winning party. But what about your own legal cost? You do have to pay your lawyers for representing you in the court case, and how much does that cost? And the short answer is it varies greatly because it depends on the time spent, and that would also depend on, has there been time spent on a massive preliminary injunction, typically in IPR cases? Has there been a court-appointed inspection and expert appraisal? So has an expert been out looking at the construction site or the building you have built, or whichever your case is about? Then obviously that will increase the time spent, and thereby also the total cost to your own representation. And also the actual trial itself, does that extend over 1 week, or is it a 1-day trial? So all of that kind of points and decide how expensive it will be, or how cheap it will be. As a main rule, for first instance, I would say expect anywhere from 33,000 euro to all the way up to, I think, one of the most expensive in terms of how many hours we spent, all the way up to 537,000 euros. And that is typically it would be somewhere in the middle, but that's kind of the range that I would tell you guys. And of course, if it's a housing dispute and you're a private individual, then obviously this video isn't for you, but you can do it cheaper, and we do have teams that deal with that kind of stuff, and they're very professional. But here I'm talking to our typical clients, which are larger international clients or groups of companies who have also larger disputes. So that would be the range. So 33,000 to 537,000 euros you would expect for an instance being represented by a competent lawyer. In the appeal court, then you can ask yourself, okay, will this then double? And typically not. Typically the fees would only be half. on average for the appeal case, simply because the case has already been prepared extensively in the first instance, and also because in the second instance you typically wouldn't have witness testimonies, you typically wouldn't have the expert witness who needs to explain his findings on his on the on-site visit if it's a construction dispute. So expect that the first instance will be, as I explained, and the appeal court. The second instance, if it does go to appeal court, then it will be half of that, sometimes even less. And how do lawyers bill in Denmark? The main rule is, as it probably also is in your home jurisdiction, is that we bill based on the time spent on the matter. The advantage of that is you kind of hedge the risk for both parties. So if it's easier than expected, you get it cheaper, and if it's more difficult than expected, then the lawyer doesn't lose either. But we do see that success fee arrangements are beginning to become more prevalent and relevant in some cases. And this is due to the fact that the Danish Bar Association, they kind of lifted a previous ban, almost entire ban, on success fee arrangements. So what we see now is you would typically not have the full no cure, no pay scheme as you would see in like personal injury cases in the US, as I understand it, because it's just too risky for the law firm. It would need to be a very, very high upside in order for me to consider that. But what we can see, and what we sometimes do, we as lawyers and our law firm, sometimes we would do there are kind of three different options here. Sometimes we would do a base fee plus a success fee. So we would do a base fee of a certain amount that has been agreed, or we just stop billing after the first 6 months of the case, and then we change into a success fee arrangement. And if we do a short story time here, I had a court case regarding warrants, and I represented the combined C-suite or ex-C-suite of a large company, and they were all their contracts were terminated without being permitted to exercise their warrants, and it was a multi-million euro case, so it was relevant for them to pursue. But on the other hand, they were private individuals, even though they were high net worth individuals. So they asked us if we could do some sort of success fee arrangement. And what we did was we had a base fee, and then we did a percentage of any winnings as a success fee. And the result, our client settled during the court case, and very successfully so, I might add, and everybody got paid and everybody was happy, except the opposing party, of course. So that's an option. Another option we sometimes work with, because it's less volatile, is we have like a half fee, triple fee arrangement. So that means that we will charge half of the hours, the billable hours on the case, no matter whether the client win or lose. And if the client wins, and the win will be defined in advance, so it might not be the full 10,000 euro in the example, it might be or 10 million euro in the example, it might be 5 million, whatever we have set as a realistic and satisfactory win. Then if the client wins, then we would charge triple the hours we have billed on the case. So basically it's half price if you don't win, and then it's 3 times the price if you do win. And of course, it's entirely up to the client whether any of this is attractive, and we prefer, in all honesty, just to bill based on the time spent on the case. But we do try to be flexible if necessary in the client's particular situation. All right. So the point of this is not so much that you understand the specific arrangements and what you should do, but it's just to let you know that there are options, and you should talk to us about that when you do have the need for litigation or arbitration in Denmark. The next thing, if you can, so that's basically the cost. So we covered the court fees, the legal cost to the winning party if you're the losing party, and vice versa, and we talked about lawyers' fees. The next thing I'd like to talk to you about is just briefly choice of venue. You can't always choose the venue you will have the court case in, because typically that will be determined already by contract. But what you can do is sometimes you can choose. Sometimes you can choose whether it's whether you will file the case in court or whether you will file the case with an arbitration tribunal. If you do that, you should just know the differences between it. So in the court system, you can always appeal the case, so that will prolong the case, but sometimes it will also ensure that you receive the actual correct ruling, judgment, verdict. The court system tends to be cheaper, as mentioned in the beginning, but note that any judgment will be public. So even though you can redact certain very sensitive information, but as a main rule, you can't redact all the things you want to redact. Of course, you can redact major company secrets, trade secrets, etc. But just know that it's within the public domain, and people and the press will be able to gain access to it. If you do have a judgment from the court system in hand, then you can enforce that in the entire EU quite easily, but you cannot enforce it in the rest of the world. And that might be an issue if the company you want to get money from is not located in Denmark, where you get the judgment from. In terms of arbitration, note that it's one shot, so there are no appeals unless there's been something fundamentally wrong in the way that it's been conducted. It's a private court system, so it's completely confidential as a main rule, and nobody can gain access to it. It tends to be more expensive because it's a private court, so basically you have to pay everything in the court. The upside to arbitration when you do have an arbitral award in your hand is that you can enforce it in almost all countries in the world, at least any country that is a party has acceded to the New York Convention, as it's called, on recognition of arbitral awards. So it's quite easy, and we are having a case currently where we have an arbitral award from Dubai, and we're enforcing that in Denmark as an example. So that's the pros of arbitration. I do want to talk a bit about what does the process look like. I mean, how does the court case, arbitration case, how is it conducted from beginning to end? And I'm not going to go into all the details here, but I'm just going to go into the details where we feel that we have something that you need to consider, or maybe a best practice or a tip for you. Before filing the claim, people tend to think from filing the claim and onwards, but there are a few things you need to consider before filing the claim. Consider or choose venue if you can, if that's not bound completely already. Sometimes it's multiple contracts and they have different venues, etc. You probably know what I'm talking about. If it's been a long-term relationship, you can have 3 or 4 or 5 different contracts, a framework contract and specific purchase orders, etc., etc. So do consider which venue to file the case in. Consider whether you need to conduct a preliminary injunction. That's typically relevant in IPR cases. So if they are using your material on their website, if you do believe that they are holding on to your trade secrets, then maybe you should get someone, have a preliminary injunction, where you basically have also what's called like an isolated evidentiary evidence collection, where the court comes out without warning to the opposing party and basically confiscates all their computers, all their laptops, in order to search it and then deliver it back to them. It's a quite harsh means for the court to use, so they would expect you to lift a quite heavy burden of proof before they do accept to go out and just collect evidence without the other party being heard in advance. But do consider if it's relevant to the case. Also think about how to pick the lawyer or the law firm to represent you. I would always pick a law firm of a certain size. It doesn't have to be the biggest, but just make sure that they do have some sort of redundancy and some sort of professionalism and standards. You should consider whether litigation experience might be more important than industry experience. I tend to gravitate towards that litigation experience is more important than being a specialist in the specific subject matter area. And that's because litigation is just a different beast. It's just it's just really something you need to be good at in order to understand all the nuances, all the kind of, not the loopholes, but the exceptions to the rule that the opposing party is going to try to use and enforce against you. So I would always choose someone with real litigation experience instead of choosing the specialist in your industry that doesn't go to court, as an example. But there are pros and cons to this. And just a side note, I would always pick someone who has the right to appear before the so-called high courts, which is the appeal instance. And they would typically in Denmark have an L next to their name or next to where it says lawyer. That's just the Danish first letter for the high courts, Landsretten. Just to make sure that you don't have to switch lawyers between the district court and the high court if it is appealed. And in the end, when picking a lawyer, it's a lot about chemistry as well. Do you want to spend time with this person the next year, maybe 2 years? So it's a side note, but it's not irrelevant. So I would consider that as well. And another thing, before filing the claim, we're still in the pre-filing of the claim phase, I would consider making a settlement offer to the opposing party in writing. And this is due to the reason we discussed earlier. It's to reduce the legal fees you have to pay to the opposing party if you lose. And also, it might just be a good idea to settle the case, because even though you feel that you have a very strong case, I almost guarantee you that the opposing party thinks that they have a very strong case as well, and that you're in the wrong. And the truth is often somewhere in the middle. So do consider settling before going to court. Just because you go to court doesn't mean that you can't rescind the case and you can't settle, but you should also consider it before going to court. As my dad used to say, my dad's a lawyer, he used to say that the only two people who for sure win if you go to court are the two lawyers. And although I don't entirely agree, I do believe that there is some truth to that. So do see if there's a commercial solution for you instead of going to court. If we do look at the process of the actual court case, like now we discussed the pre-court case, steps you might want to take. If we do look at the actual court case, it will probably resemble what you have seen in your own jurisdictions as well. It'll probably start off with a claim form, and then the other party files a defense, and then what we call a reply, and then a rejoinder, and then so on and so forth in terms of written filings. In addition to all the written filings, you can expect that the court will call for an initial court hearing by phone, which is it's only the lawyers that participate and the court, and they do want to discuss some practical matters and your calendars and when can we meet for a trial, but they also tend to talk a little bit about the case and whether the parties have tried to find an amicable solution along the way. And they will try to recommend a court-led negotiation. It's voluntary if you take it or not. We have had one case where it was detrimental to a party later on that they choose not to go to the court-led negotiations. But it's not the main rule. So as a main rule, it's completely fair to say no. I don't feel that we can find a solution if we do meet at negotiations. But the court will almost always ask you. And if you do if you do want to go to a court-led negotiation, my experience is that 1 out of 3 cases that go to court-led negotiations will actually be solved there. So that's a decent hit rate. I think the official numbers from the courts are the success rate is higher, but I have just not seen it in the cases I have had in court. Okay, so that's a court hearing by phone, court-led negotiations, which might also be occur somewhere along the way of the preparation of the case. Another thing that might also be relevant is the inspection and appraisal by a court-appointed expert, and that's typically if it's something we need to visit on site, if it's a building project, or if it can be many things. But then the parties will appoint, or the parties will suggest an expert that they can both agree on, obviously an impartial expert, and then the court will approve. Then the expert is hired to inspect and make a report on whatever this court case is regarding. So that typically takes a bit of time. Witnesses, and we'll come to the trial afterwards, but witnesses, when we are in the preparatory phase here, you are allowed to contact witnesses before the actual trial. You can contact both your own witnesses and the opposing party's witnesses, and there are certain ethical rules for lawyers on how to do this, but as a main rule you can contact witnesses before, but they do have a right to refuse to talk to you. Written statements are permitted, but would be unusual to have in court. The evidentiary value of it tends to be less than if the witnesses actually appear in court. And so it would only be if it's someone where it's not feasible for them to fly in for the actual trial, then you might consider doing a written testimony instead. There's a cutoff date, typically 8 weeks before trial, and after that date you're not allowed to introduce new documents, and that's a main rule with some exceptions, and sometimes you will be permitted to present new documents as well if they're important and if they do fulfill certain criteria, then you will be permitted to include it. A quick story time here. I have had people rock up in court with new documents, and that being permitted against my objections. So as a main rule, Danish courts will try to find the truth of the case and will rely less on formalities. So they tend to just allow everything. The same goes for any evidence that has been illegally obtained, that will also be permitted in court. So any illegal recording will not be barred from being presented as evidence. It will be also permitted. So that's just for your information, because I know that differs from some of the jurisdictions you may be in. Immediately before court, 2 weeks, 4 weeks before, we as lawyers, we produce a lot of documents. We do need to provide a summary of claims and defenses, which is basically the summary of everything we've written in the past. This is how we see the case, and this is why you should win the case. We do need to compile the so-called trial bundle, which is all the relevant documentation from the case, all the evidence. We'll also have what's called in English, a document bundle, which is all the case law and all the legal literature that we will use to support your case or our case. So that's prior to the actual trial, prior to actually going to court. In the during trial, and I'll just run through it step by step. The first thing that will occur is that the court will obviously ask who's here and do you still maintain your claims, and once the parties have confirmed that, then the attorney for the lawyer for the claimant will begin a so-called submission to the court, where he has to present the facts of the case and go through all the evidence, the schedules, this is the agreement, etc. And this presentation of the facts is supposed to be objective. So it's supposed to be the same the same presentation of the facts, whether it's this party's counsel or this party's counsel that is presenting the facts. But the truth is that the battle has already begun. So of course some lawyers will try to slant some of the facts slightly in their favor, and sometimes we also see people omit certain facts. So we as lawyers, we do need to be very we do need to be very alert during this phase to make sure that all the documentation that points in your favor will also be presented. Then after the submission to the court, presentation of the facts, we go to the party testimonies. So that's a representative of the party, typically a manager, the CEO. It could also be a board member or the chairman of the board. And we do tend to get the question from international organizations and companies that, do I need to appear in person? And the answer is no, you don't need to appear as a party, but it is highly recommended. And if we take a quick story time, I have only had one case where my client decided that it wasn't relevant for him to appear and give a statement. So he not only did he not give his statement, he didn't appear in court at all. We lost that case, just full on 100% loss. And I'm not saying that's why, but it does tend to give off a vibe of you having something to hide, or you're not believing in the case yourself. So I would always recommend that you show up in person. Then if there's been a court-appointed expert, then after the parties' statements, then the court-appointed expert will come and will come to the court and can be asked questions about the expert report that he would have prepared in advance. So that's basically, the foundation of this building or this huge shopping mall or whichever our client has built has a major flaw, and these are the, whichever. So the parties can ask him questions and obviously try to turn things in their favor. Then we go to the witness testimonies, and witnesses will either be in person, which would be typical. It could be written and written testimonies. We discussed that. It's not really, it doesn't hold the same value. Sometimes the courts do accept a Teams interview. So basically the witness give their testimony via a court system, kind of Teams system that they do have. But they would have to be present in another courtroom in Denmark. So it's only if they're in the other part of the country, then sometimes they can go into a court there and provide their witness testimony. Then after the witness testimonies, then it is the lawyer's time to do their closing arguments, which you would probably also know in your jurisdiction, where we kind of just try to win. We have, of course, prepared this in detail and rehearsed this prior to the trial, but many new things occurred during the trial, so that's also one of the reasons why it makes sense to have a experienced litigation lawyer doing the court case, because we do tend to know if something kind of rocks the boat and changes the case, then we know how to handle it. So that's very interesting, and cases are won and lost in the closing arguments, although most of it might be in the actual facts of the case. After the lawyers have presented their closing arguments from the counsels, the court sometimes will give their preliminary view on the case, and they might say, do you want a preliminary opinion from us? And you would typically say yes, if it's non-binding, which it isn't. And then they might say, look, we find that the claimant will prevail or succeed in claims 1, 3, and 5, and we encourage the parties to settle in accordance with that. And then it's entirely up to the parties whether they want to follow that advice. If not, you just say, thank you for that, we would like a written judgment. And the court will say, yeah, sure. And then you will receive a written judgment instead, so you can actually appeal the case, which you can't if you settle, obviously. And the final judgment will be uploaded to the digital court portal after 4 to 6 weeks, depending on the instance you have been in. After that, you will have a deadline of 2 to 4 weeks to appeal the case, if you want to do that, or alternatively for the losing party to pay in order to avoid accruing interest. so that's basically the actual trial from start to finish, and all the preparation of the trial and the actual trial from start to finish, including our tips and best practices. A few things that might differ from your home jurisdiction, just based on my experience and what international clients have told me after we have conducted a court case. One of my clients, he was American. He was very surprised that there wasn't a lot of objection, Your Honor, as we see in the movies, and apparently as it is in the US, at least according to his explanation. And that doesn't mean that you can't. We don't really use that a lot in Denmark. It tends to be slightly more informal. The actual trial. That doesn't mean that you can't object to if the opposing counsel does anything he's not supposed to. He's making leading questions. He's kind of abusing, badgering a witness. Of course, you will intervene directly, and then the court will handle that. Typically, it won't be in terms of an actual ruling that could be appealed, but it will be as part of the court precedent's task of having order in court. He or she will make sure that your objections are heard. In general, in Denmark, and I'm not saying that this differs from your home jurisdiction, it's just a discussion I've had with some clients from a part of the world where you can be concerned whether the judges can be corrupt or whether they're impartial and so on. As a main rule in Denmark and in the Nordics in general, we have a very high standard of integrity and legal acumen as well within our courts and in our judges. Very highly skilled people. I rarely see a judgment that is not in line with what would make sense. Obviously, we don't like to lose, but we will always know that if it's a 50-50 case, then obviously there's a 50% risk of our client losing. Corruption is virtually non-existent. It just doesn't occur. I don't think we have any case law on a corrupt judge, to be honest. And in terms of impartiality, we can do a quick story time here. A number of years ago, as a young lawyer, I was dealing with an employment law issue. I was representing the employer. I think they had terminated an employee, and I went to court, and then the judge came in. It's one judge in the first instance and 3 judges in the second instance. So the one judge came in, and he looked around, and he was like, "Okay, let me just see who's here." And I presented myself and this, and then he looked at the plaintiff, the claimant, and he was like, "Is your name, so and so?" And he could see in the papers that it was, but it was a very generic name. So he even though he had reviewed the papers in advance to make sure he was not impartial, then it was a very common name. So when he saw her, he was like, "It's you." And then he was like, "Okay, there might be a conflict of interest. Give me 2 minutes, or give me 5 minutes. I need to consult with a colleague." He went outside the door into the judge's chamber, and he basically he shut the door, and he just came out right away. And he said, "No, I can't do it. Your kid has been home playing with my kid. I don't believe we've ever spoken, but this is just too close." And it's not because he was not able to be impartial, but it's the appearance. The appearance of impartiality needs to be upheld as well. So this is just to show, and to be honest, I wouldn't have had a problem if he had presided over the case regardless. Neither did my client, because they never spoke, and they were not friends, etc., etc. And it's a small town. But I do have a lot of respect for him kind of recusing himself in that situation. So this just goes to say that there's a very high standard of integrity in the Danish courts. So that was a quick, 44-minute lead into the Danish court and arbitral system. We have discussed how long time does it take, how much does it cost, what does the process look like, which tips and tricks should I implement along the way. And if there is anything that you feel that I have not covered here, then feel free to reach out to me. My contact information is in the description. And if your company does have a dispute in Denmark, then let's set up a call. And if your case qualifies, then maybe we can work together. And also, as a last note, if you could do me a personal favor, then please like this video. This video obviously is only relevant for a very niche audience. And your like will show the algorithms that it's valuable so others can find it as well. So thank you very much. And this was Nicholas Keller, a lawyer in Denmark.